So today it looks like we have a number of great questions. Looks like we have about 15 questions from our panel today. So the first question is a board member, and it says, per Arizona statutes, I started recording our board meetings. Another director announced that he'd miss the next meeting. Is there anything wrong with providing the video to another board member? So definitely not. You certainly have the right to do that. Recognize we have a cheat sheet on this topic too that's very helpful, called Arizona Open Meeting Laws and Rules for Recording Association Meetings. There's a statute in Arizona that specifically addresses owner's ability to record association open board meetings, and the board can record the open board meetings. So of course you can provide that to another board member. If this recording is an official record being taken by the association's board, an owner could also request a copy of that recording. So I just wanted to make you aware of that. Okay, next question is from a treasurer at an association. Is the legislature still seriously considering eliminating the requirement that an HOA is required to send out monthly statements to every owner, regardless if the bank pays many of them automatically? So are they seriously considering it? At this point, I can say no. This was a bill that was passed prior to the pandemic, I think in 2018 or 19 by our legislature, and it is a complete waste of money. Basically, it requires the association to send out a statement of account to every owner every month, if your assessments are monthly, every month, letting them know, how much they owe. There was a bill in the 2022 legislature, House Bill 2730, that addressed this topic and, changed it up so that associations, wouldn't have to provide it to every owner. Maybe it was only to the owners that had a delinquency with the association, which would be a fix that would be appreciated. But that bill hasn't been going anywhere since February 10th. Of 2022 in the legislature. And typically, if the bills aren't moving, especially right now, and have been passed by, at least one chamber, it's not going anywhere this year. So that'll be something that we'll likely see be introduced again in 2023 in the legislature. And just from my standpoint, that is a necessary bill. That is an expense that is unnecessary and just a waste of resources for associations. So I hope that the legislature will step up and fix that in next year's legislative session. Okay, next question. With help, let's see. We are in the process of amending our CC&Rs and articles. If the CC&Rs pass and the articles, which required 2/3 vote of all owners, do not pass, can we implement the revised CC&Rs? Okay, so great question. So it looks like your association has, you're trying to amend both your CC&Rs and your articles. You're likely doing this on the same ballot, and the ballot is likely indicating that the CC&Rs have a certain percentage to approve and the articles have a different percentage to approve. If the ballot comes back and you get the requisite approval to amend one but not the other, yes, of course, the one that you have the requisite percentage on passes, and we go through the whole amendment process to formalize the amendment. Next question is from an owner. Can an association member or owner file a lawsuit on behalf of the association, especially if the association lacks funds, as 7 rental units out of 26 are making legal fee expenses significant, and the association's budget lacks funds because of this? So really good question from an owner. If I were in your circumstance, what I would do is I would look at what the CC&Rs state on this for your association. Sometimes it is kind of rare, but sometimes an association member can file a lawsuit to enforce CC&Rs. Now, of course, they can't do it on behalf of the association because only the association, can represent themselves through legal counsel. But in some cases, association members have the legal right to enforce the CC&Rs against another member. It's rare, but in some cases that does happen. What you may want to do is, if you don't have that provision in your documents, is you may want to really evaluate You may want to get on the board so that the board starts making better decisions on how they're using their funds. You may want to think about potentially sending a letter to the board, asking why they're spending money on certain things and not others. These are some options that you have. Also, you always would have an option to pursue legal remedies against the association, whether it's through the Arizona Department of Real Estate, through their program that they have through that, where you can have disputes heard, or through litigation. So you do have a number of different options. Check your CC&R so to see if you have the right to act on behalf of the association in terms of enforcing the CC&Rs. Next question. We have 4 sets of CC&Rs for our HOA, and there are 225 homes in our HOA. Can I merge the 4 documents into one with no changes without the owners voting? So answer to that question would be no. You'd have to have a vote of each of the sections. Typically, this is probably structured as, lots 1 through 50 have one set of CC&Rs, 51 through 100 have another set, or however it was set up in your association. So bottom line is, no, it's not that easy. You're going to have to amend each of those 4 CC&Rs to incorporate it into one CC&R. And so you're going to kind of have to decide, is it worth it? We've gone through this process with associations before, so I have some good insight on how it can be done successfully. And if your association is interested, be sure to reach out to me and I can give you some feedback on how to do that. Okay, question 6. Can you address the HOA's rights if a homeowner wants to rent his house to an agency that runs group homes? So yes, I have a wonderful cheat sheet on this topic on our website at mulcahylawfirm.com. We're also going to be sharing it with you here on Zoom and Facebook Live. It's our cheat sheet on federal laws. And basically, under the Fair Housing Act, in certain circumstances, group homes are permissible as, to be able to operate a group home within an association. And a couple things that, you want to look into is, first, you want the association, if you're in this circumstance, you should request documentation from the group home operator that verifies the existence of a disability. That the group home is for disabled persons, and therefore it falls under the Fair Housing Act, and we'd be required to allow the group home to operate in your association, despite the fact that most associations have a no business, can't run a business out of your home, and obviously a group home would be a business. But the federal law trumps here, and so if it's a group home that's covered under the Fair Housing Act, the association would have to allow it. So the question I have is, what are our rights if a homeowner wants, to have a group home in the association? So number one, ask for, information from the group home operator about, who the residents of the group home are, and check with your legal counsel to make sure that the group home is covered as, one of the group homes that's covered under the disability related needs, under the Fair Housing Act. So ask for more information. Number 2, if they are something that is covered under the Fair Housing Act and we have to allow the group home, remember that they have to follow the rules just like any other owner would have to follow the rules. So the residents and any employees which may be coming into the association would have to comply with parking rules, and visitors would have to comply with parking rules, and they'd have to maintain the property, and there'd have to be, trash would need to be disposed in an appropriate manner. Just like any other owner would have that requirement. And so, they have to maintain their buildings, maintain their landscaping. Any changes to their architectural modifications would need to have architectural committee approval or board approval. If there's any noise or other nuisances that are being created by the group home, we would be able to treat that just like any other owner's violations would be treated. So one thing, just some closing thoughts on the group homes is, I have been through this process with a number of associations, and initially the boards are upset and unhappy about a home being used as a group home. But what I've found is that the group home operators typically are very good owners. They pay, they maintain their property, and there really aren't any issues that come up with regard to parking or nuisances. So, that's just important for me to share with you. If you're navigating that process, it has been a positive for many other associations. Okay, question number 7. We have a person who wants to do away with most CC&Rs and bylaws in our association. He believes we are all neighbors and we should get along, and that the CC&Rs make it too hard to get things done. How would you respond to this person? Well, there's a process to, eliminate CC&Rs and bylaws, and it's a very difficult, process. So it's an easy short answer would be, move to a community that doesn't have a planned community or condo, right? No CC&Rs and no bylaws. That's the easy answer. The hard answer would be, you can't just do away with these things because there's an expectation that people purchase their lot in this association because of the CC&Rs. And of course, if, you look at your CC&Rs and, that there's a percentage to, remove the restrictions from your property and invalidate the CC&Rs, if you can get that percentage vote as outlined in your documents, then of course you certainly would have the right to do that. Now, if you're thinking about doing that, you definitely want to talk with your legal counsel. But in my experience, it's very difficult. I think in 25 years, I've maybe done 3, associations where we wind down the affairs of the association and remove the restrictions on the property. It's very difficult. So it's not something that we see very often. And the board doesn't have the option to just look the other way and not enforce the CC&Rs and the bylaws. They have a fiduciary duty to act in the best interest of the association. So that's, not something the board can do, just blow off the documents because maybe owners don't want them to be so strict. One thing you might want to think about doing is doing an amendment to your CC&Rs. If there are provisions in there that people see as being too strict or whatever, that's another option that you can think about for your association. Okay, next question. New homeowners move in. They made changes to their front yard without notifying the board. According to our CC&Rs, they are in violation. What is the best way for the board to handle? Okay, so we have a cheat sheet on this topic too. It's called Enforcement of Governing Documents. And you can find that on our website at mulcahylawfirm.com on our cheat sheet tab, or we're sharing it with you now on Zoom and Facebook Live. So really the best thing to do would be to start out, they're new owners. I would recommend that you send them a courtesy violation letter. I would recommend that you follow whatever your enforcement procedure is. Then maybe it's a more formal demand letter. Then maybe it's fining the owner. Then maybe it's sending it to the attorney to send a violation letter. You may be going the litigation route. You may go to the ADRE and have a complaint filed with the Arizona Department of Real Estate. It really just depends. Hopefully this can be resolved amicably. They're a new owner. Maybe their changes aren't that significant that a phone call could, rectify the issue. But I think we outlined for you really well in our cheat sheet on enforcement of governing documents, a good process for you to follow that I think would be helpful. So I'd encourage you to take a look at that. Okay, question number 9. Does the cost to update CC&Rs also include updating the bylaws? Do the homeowners vote on the revised CC&Rs and bylaws? So what you want to do is for the CC&Rs and the bylaws, you'll have to look at, they both have a different amendment provision, right? And, you can vote on them at the same time. You can vote on them separately. You can put it on one ballot. You can put it on 2 ballots, whatever's easiest for you. The cost to update the CC&Rs, kind of the general range of the costs that I gave earlier in this presentation, did not include the cost to update the bylaws. Typically, the bylaws are a much simpler document to amend. They're always shorter, and a lot of the changes to state law are pretty easy to make to the bylaws. So I would budget maybe somewhere between $800 and $1,200 to amend your bylaws. And like I said, the cost to update the CC&Rs could be really anywhere from $1,000 to maybe all the way up to $8,000. Average is probably $5,000 to update the CC&Rs. So the homeowners are going to vote on, typically you got to look at what the amendment provisions say, but they're going to vote on the amendments, the CC&Rs and the bylaws. And like I said, you can do it together or separately. Our next question number 10. And it looks like we're up to, gosh, we're going quick. We've got 20 questions now. Question number 10, can you suggest a methodology for our board to legally obtain signatures for yes votes when we propose homeowner approval on CC&R provisions or any other major issues? Are DocuSign signatures appropriate, or do we need a hard signature? Again, look at your CC&Rs to determine, will they allow you to send out a vote, electronically, or do you need to have it notarized, a hard signature notary? We are starting to see a lot more of these votes being conducted electronically, and that seems to be a very successful way to do it. But again, it has to be consistent with what your amendment provisions are for your CC&Rs. Question 11, can you elaborate more on a side vote for controversial issues or items? Sure. Typically a controversial amendment, I'm going to give you an example, would be maybe you're amending your entire CC&Rs, to rewrite it, make it clearer, make it consistent with Arizona law. And then you also want to add something in there like on a capital improvement fee. So you want to say that every new owner who purchases a lot in the association must pay a capital improvement fee or a transfer fee of $2,000. That sometimes can be controversial. Or rental restrictions. Maybe you want to impose a minimum rental period of 6 months. So owners can rent, but they can only rent if it's up to, has to be a lease for 6 months. Those are kind of controversial. Anytime there's money or rentals, those kind of seem to be a little bit more controversial. So if I was structuring the amendment and we determined that, hey, that's going to be controversial, and I'm not sure we can get the percentage that we need to amend on that document, so what you want to do is maybe have the CC&Rs have a ballot, and the first vote on the ballot is up or down, amend the CC&Rs, yes or no, and give the owners the opportunity to vote on that. Then the next vote is going to be on the transfer fee or the capital improvement fee, yes or no to approve that. The third vote might be yes or no to implement the 6-month minimum rental period. That way, if the second and third vote don't pass, the first vote may still pass. And the first vote, of course, doesn't have those two controversial things in it. And so that's kind of a way to structure it. And typically we only do that if we have a feeling that we can't get 67% or 75% of the owners to agree to those changes that are more controversial. And we've made a bunch of other changes to the document that we want to have passed that are not controversial. And we think we can get the 67 or 75% or whatever the percentage is. That's a suggestion that we do to try to get over that threshold and get at least one of the things passed. Okay, next question. If an association recorded its last CC&R restatement more than 30 days after approval by the requisite percentage of the membership, but the validity of the restatement was not challenged within 1 year of the belated recording date, is the restatement valid or invalid? It's likely still valid. For a condominium, there's 1 year to challenge the amendment to the CC&Rs. I'm guessing you're a condominium because you're bringing up the 1 year. So I still think it's valid. And sometimes, that happens where you blow it on the 30 days, you still record it. And if no one challenges it, it's considered valid. Same thing in terms of if you're a planned community and you blow it, you don't get it done within the 30 days, you should obviously make best efforts to do that. But if something happens, there's a mistake, there's going to be 6 years for them to challenge it. And so you'd have to wait longer than the 1 year for the challenge on that. But it doesn't make it invalid during the 1 year while if they're waiting for a challenge. It just, if somebody does challenge it, then you want to get your legal counsel involved and start thinking about, how can we address this situation? Okay, next question, number 13. How do you determine ownership for the upkeep of the surrounding HOA walls? Those facing into our community, we repair and paint. We have one back wall that faces another HOA greenbelt. It needs a lot of TLC. Who owns the responsibility? Some board members say the other HOA. That's a legal issue that we're really going to have to look at the CC&Rs and the plat to determine who's responsible for the maintenance of it. Also, is the wall located on the property line? If it's on the property line, typically that other HOA is going to be responsible for maintaining their side. And you need to reach out to them and let them know that it's not being maintained and causing issues. That's probably going to be the answer on this one. But again, I'd like to see your CC&Rs and your plat to make a final determination. Next question from a long-term client. Good to see you here today. Do you vote for all the changes or each change individually? So we're talking about CC&R amendments. Typically we'll vote on an all or nothing vote for all the changes at once. Occasionally we'll break it out on those controversial subjects and vote on those individually. I do not, under any circumstances, think it's a good idea to take a 40-page document, CC&R amendment, and have owners vote on each amendment in the 40 pages. I think that's a bad idea, and it'll be confusing to the owners, and it'll take forever. And you likely won't even get people to respond because it's so onerous, so much work to do it. So, okay, next question. What are your thoughts on restricting rental sex offenders or those with a history of criminal offenses? Creating rules requiring owners and landlords to do background checks prior to accepting rentals. Please share your comments on this. Okay, this is definitely a controversial topic. So this all kind of came about at, in, I think it was 2006, it's been a while now, where our legislature put a section in maybe it was a little later than that, maybe it was 2012. Anyways, our legislature put something in some changes to the statutes that talked about sex offenders. And basically it said something along the lines of an association is not prohibited from enforcing a CC&R provision, restricting certain level sex offenders. And it was worded kind of weird because the way that it was worded was our legislature, and this is the law, it said an association is not forbidden or prohibited from enforcing a CC&R provision limiting or restricting sex offenders. Well, the reality here is that no CC&Rs that I've ever seen have had a provision restricting or prohibiting sex offenders from living in the community. So it was almost like, was the legislature giving us the green light to implement restrictions to our CC&Rs that would give us the ability to prohibit, sex offenders? I don't know. But what I can tell you is, be careful. If you're an association that wants to, prohibit sex offenders, there may be some issues, constitutional issues, that could make something like that, a challenge on something like that, be very expensive, go all the way to the Supreme Court of the United States. So I would not advise our clients to implement restrictions in your CC&Rs prohibiting sex offenders unless the client understood the risks and understood that, hey, this could be challenged and this could be very expensive to defend. On a different note, what about residents or tenants that have criminal background? Maybe they're felonies or misdemeanors or whatever. Can we require owners to do background checks prior to accepting, such a rental? I think the way that the legislation is currently worded, we cannot ask I know that the way that the legislation is currently worded, we cannot ask landlords to provide us with criminal background checks on their tenants. That is not something that the association can mandatorily require owners to provide that are renting their units or lots. If we wanted to place a responsibility on owner landlords to do criminal background checks, that would be something that would have to be in the CC&Rs. And you'd have to do an amendment to the CC&Rs. But I still think, based upon the way that the wording of the statute, I don't think we could require that they give us the criminal background checks as the association. We could just make it an obligation of the owner to do that, but it'd be really hard to enforce because if they don't have to give it to us, how would we know it was ever done? Remember, just on the topic of sex offenders, June 1996, Arizona legislature adopted the Arizona Sex Offenders Community Notification Statutes. If you Google Arizona and Megan's Law and type in your address for your association, you will find any sex offenders that are living in the vicinity of your association, so that you're aware of them. Also, occasionally associations will receive notice from the sheriff's department or from parole officers that a sex offender is moving into your neighborhood. We have seen that happen in many associations over the years. The best advice we can give you is to notify your membership. Just forward the paperwork that the sheriff or the parole officer sends to the association. Just notify the owners of the same information so that all owners are notified that a sex offender is living in your association or in close proximity to your association. Okay, next question, number 16. Where do disabled and elderly people find answers to how the CC&Rs are changed in the community that they have lived in for over 40 years by new owners? Where do they start? Great question. So hopefully you have a contact number for your association, or an email for your association, or a place where you send your monthly assessment or quarterly assessment. What I would do is to reach out to your management company or your board through one of those means, by emailing them, calling them at a number for the association, or when you mail in your assessment payment, put a letter in there saying, I would like to have a current copy of the CC&Rs for our association, so that you get a current copy. Also, if you're savvy on the internet, you can go to Maricopa County Recorder's Office website, type in your association's name, and do a search for restrictions or CC&Rs on the property, and you might be able to find it that way as well. Okay, next question, number 17. How does a planned community dissolve an HOA? Wow, second question on this today. You're going to have to look at your CC&Rs in terms of what the percentage is to dissolve an HOA. Typically, it's like 80%. It's usually what's in the CC&Rs. Sometimes it's 100%. So you'll want to look at your CC&Rs, and you want to involve your legal counsel, because there's a number of steps to undo or dissolve an HOA. You have to amend your CC&Rs to dissolve the association. You have to determine what's going to happen with the common areas. The association owns them. We're paying, insurance on them. Well, how is that going to work? Will the city, town, or municipality take the common areas back? I doubt they will. We have to also undo the corporate status of the association, and undo the bylaws. So there's a very lengthy process that you have to follow if you want to dissolve your HOA. Next question, number 18. Our bylaws and CC&Rs are beyond 30 years old. Should we start with the CC&Rs, or can we start with the bylaws? Ideally, do them both at the same time. It's more efficient, cost efficient, to just bang it out and get it done. But if you had to pick one or the other, I would start with the CC&Rs, because that is probably the most important document for your association, in my opinion. Question number 19, are renters allowed to attend HOA monthly meetings? Why or why not? We have a great cheat sheet on this topic called How to Effectively Work with Rental Properties that I would encourage you to take a look at. Number one, the Arizona legislature or Arizona statutes do not give renters the right to attend HOA monthly meetings. It's basically just owners are allowed to attend the monthly meetings of the HOA. Also, owners can appoint a designated representative to attend a monthly board meeting. And so the owner could make their tenant or renter their designated representative in writing, and then the tenant would legally be able to attend the meeting. So really the only way that a renter would be allowed is if the owner made them their designated agent in writing to attend the board meetings, and then the renter would be able to attend. Otherwise, no. The renters are not allowed to attend unless the board allows them to attend. Some boards do, most boards don't. Okay, next question. Our neighborhood association maintains an email distribution list of homeowners. Based on feedback from the majority of the homeowners, these are privately maintained and not shared with other homeowners without permission of the homeowner. Recently, we received pushback saying that we are blocking free communication among the homeowners, calling it secrecy. There's nothing in the documents relative to how the distribution list is maintained. What are your thoughts on dealing with this? So my thoughts are that emails are personal information, same thing with telephone numbers, and that unless the owners specifically agree to have that personal information, their email or their cell phone or their home telephone number shared with the community, that it's personal information and it shouldn't be shared with other homeowners. Okay, next question. Our previous management company never sent out violations. We are trying to fix that with new management. If a homeowner purchased a home with violations in place, how should that be rectified? So that's a really good question because I don't know how long the violations have been around on this property and how long we've known about them, but maybe hadn't enforced them. So kind of as a rule of thumb, you're going to have to look at these on a case-by-case basis. So as a rule of thumb, you're going to need to look at, has the violation existed for more than 3 years? If so, we may be, forbidden to enforce it under waiver latches. Can we resolve this amicably with the owner by just, trying to work it out with the owner with a phone call or a nice note? If the homeowner purchased the home with the violations and we didn't disclose it on the disclosure statement, is the homeowner going to be upset and are they going to refuse to do it? All of these are really good questions that we'll just have to look at on a case-by-case basis. Question number 22. A new owner on the weekend after closing escrow and before even moving in cut down a large, healthy, very mature tree in their front yard, which is in violation of our design requirements. Since the tree is already cut down, what is the best way to handle this? How can we prevent or reduce the continuing loss of trees simply because they are getting to a size that impedes views? Okay, so wonderful question. So what I would recommend on this particular situation is you definitely need to document in writing to the new owner the position of the board that they violated the documents by removing the tree without going through the proper procedure. Typically, the procedure is to submit an application, architectural approval, and if they got permission to remove the tree, then they could have removed the tree. What you may want to do is first look at your CC&Rs, make sure that the tree removal, is something that they would have had to have approval of the architectural committee or the board to do. If that's the case and they did it anyways without approval, you may want to consider levying a fine, for the tree being removed. You may want to try to require them to put a new tree in the place of that tree so it looks appropriate. Again, I'd have to look at your documents to give you, a full range of different options, but, best way to handle it is to punish them for doing this. If this is in fact a violation, communicating with your owners frequently about how important it is. This issue is important to the board, and that if you're thinking about doing something like this, you really need permission. These are all suggestions on how you can handle that. Okay, so we finished our questions. We have a great number of questions today, 22. We had 120 attendees today on Zoom, which is awesome. That might be an all-time high, plus 20 who attended today on Facebook Live for a grand total of 140 people here today, which is amazing because it's summertime. And sometimes in summer, we see a little bit of a lull in people attending classes, but not when it's on Zoom because we can stay home and in our air conditioning and we don't have to go out, right? So thank you so much for being here today with us for class number 6 of our 2022 Virtual HOA Condo Academy series. I'd like to give a special thank you to the partnership that we have with the city of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. It's truly been a pleasure for our firm to partner with you since the pandemic, prior to the pandemic with in-person classes. And now post-pandemic, hopefully, to partner with you for these classes, these virtual classes, which give owners and property managers and board members a place to hear more about important topics in our different HOAs and condominiums, have a free resource to ask questions and get questions answered, and just to provide valuable information so that everybody can live harmoniously in their communities. It's very encouraging to see all the continued interest in our virtual seminars. We have a very high participation with the virtual seminars, and we appreciate you tuning in each month. As I stated previously in our session today, we keep videos of every single class that we teach for these neighborhood services virtual HOA academies on our webpage at mulcahylawfirm.com. Lots of people go back to them as a resource after the classes to re-listen to them and maybe show to their other board members. And all this participation of looking at these videos has resulted in over 58,000 views of our videos on our website over the past 2 or 3 years. So that's incredible. And we thank you for coming back and looking at the videos after the fact. Also, we're going to be teaching our July class, July 19th for Neighborhood Services Virtual HOA Academy. In that class, we're going to be talking about hot topics for HOAs and condominiums. We're going to go over most pressing issues for community associations, such as delinquent assessments, water issues, short-term rentals. We're going to spend some time on that. The new legislation, by then we'll have, some final updates as to what happened with all the bills in this year's legislative session. And, we like this class because it gives us some flexibility to talk about what are the most pressing issues that are facing associations right now. And it could be anything from electric cars to, water preservation to, it might even be turf, how do we handle these turf requests that started to come in large numbers. So we hope you'll join us for that class again on July 19th at 11 o'clock a.m. on Zoom and Facebook Live. Thank you again for joining us today for our HOA Condo Academy class number 6, and we hope to see you again at our First Fridays or our July 19th class. So take care, everybody. Have a great rest of the month, and we'll see you again on July 1st and July 19th.